In this week's episode of the Crushing Debt Podcast, you're selling property. What do you need to disclose to the buyer?
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law. And so this week's episode is going to be a solo episode about an issue that we are seeing come up more and more and more around the office. But before I get to this week's episode, I did want to say happy Hanukkah to all of those who celebrate. In a couple of weeks, Merry Christmas, and to whatever other holidays that you celebrate, happy holidays. I do want to say thank you to our sponsor, especially during this time of year. Our sponsor, Sam Cohen with Attorneys First Insurance. As all of you know, Sam writes errors and omissions insurance for attorneys and title companies, both inside the state of Florida and outside the state of Florida. Sam can write if you own a title company or if you are an attorney outside the state of Florida, but if he can't, he can become licensed in that state, or he can find someone who can write your insurance, but he's licensed in most every state. So if you're afraid of getting a claim for malpractice, then probably need to take a couple of continuing education classes on best practice, but also give Sam Cohen a buzz, who can make sure you have the proper insurances and the proper coverages. Happy to call Sam, a friend of mine, and he's helped me out with some insurance questions on multiple occasions. You can reach him, sam@attorneysfirst.com or www.attorneysfirst.com. So again, reach out to our friends, Sam Cohen at Attorneys First Insurance at www.attorneysfirst.com. However, what I wanted to talk about this week was an issue that comes up a lot around the office, or has come up a lot lately around the office. And so here's the way it gets presented to us, or to me. Buyer buys a property, and then something happens. Now, during the inspections, whatever that issue was not readily observant. So maybe it was an issue of the air conditioning unit not working right, or the plumbing not working right, or the electrical systems not working right. It was something that worked during the inspection, or maybe something that even wasn't looked at during the inspection. But then once the property closes and the buyer moves in, and then all kinds of stuff starts breaking, and the buyer says, well, seller, why didn't you tell me about this problem? Now, we've represented both sides of the equation. We've represented buyers who moved in and found things that were going wrong from things that had not been disclosed, and we've represented sellers who have been accused of not disclosing certain things in the sale of their property. And so the case that describes the obligation of the parties is a case in Florida called Johnson v. Davis. Now, those of you that want the legal citation to Johnson v. Davis, 480 Southern 2nd, 625. And it's a case out of the Florida Supreme Court from 1985. So what that means is that it is binding on all state courts inside the state of Florida. And in addition, I looked up other cases that have cited Johnson v. Davis, and from what I found as I record this episode, it is still good law in the state of Florida. So from 1985, it is now 35 years old, almost 36 years old if you're listening to this on the day of release. And so it is still good law in Florida. So let me give you the background of Johnson v. Davis. I'll talk a little bit about the law, and then I'll talk about the practical application of how this works and how we discuss it with clients and potential clients. So Johnson was the seller and Davis was the buyer. Now, interestingly, the contract had a right in there for the buyer. So the buyer had the right to inspect the roof. Now, what is interesting is I don't think the case discloses whether the buyer actually did inspect the roof, but the buyer, based on the contract, had the right to inspect the roof. And when the buyer was walking around the house one day, she noticed that there was buckling and peeling plaster along some of the roof line. And so the buyer talked to Johnson, and Johnson told Davis, the seller told the buyer, that the buckling and the peeling that the buyer saw was just a minor problem. It was corrected, and the stains that the buyer was seeing were really just wallpaper glue and some leftover from the repair of the roof, but that ultimately the roof was watertight. And so the buyer accepted that explanation, accepted that analysis. But then after a heavy rain, the buyer went to go look at the house again, and there was water literally gushing into the house from some of these areas that the seller had said were previously repaired. The water was, and the case even says, the water was gushing into the house. Now, let me back up and give you one more fact. When the buyer signed the contract, the buyer provided a $5,000 deposit. And after the inspections were over, the buyer paid another $26,000 deposit. So this was a $31,000 deposit. Well, of course, the buyer said, there's all kinds of issues with the roof. I don't want to buy the property. The seller said, tough. We're beyond now all of the inspection periods and your rights to cancel. You have to buy the property. The buyer said, no, I don't want to buy the property. And a fight over the $31,000 deposit ensued. That's what this case was about who got to keep the $31,000 deposit when the buyer backed out of the contract. Now, a lot of attorneys, me included, have taken this case to apply to situations where there's actually been a closing. And I think by analogy, that works. But in the actual case, Johnson v. Davis, there was no closing. This was really a dispute over the deposit. And so after the trial, the court awarded the $5,000 deposit to Johnson, to the seller, but awarded the $26,000 additional deposit to Davis, to the buyer. Now, the case really doesn't go into why $5,000 was awarded to one and $26,000 was awarded to the other. There are other cases leading up to the Supreme Court's decision. And if you want, let me know. I can pull those other cases and do an analysis for you and let you know, some of these more facts. But I'm just trying to give you here the 50,000-foot overview. So the trial court awarded $5,000 to Johnson, to the seller, and awarded the $26,000 additional deposit to the buyer, to Davis. And so the fight ensues. And it goes through a couple levels of appeal and then ends up in the lap of the Florida Supreme Court. And so one of the things the Florida Supreme Court did was they looked at this issue of misfeasance versus nonfeasance. And for those of you wondering, misfeasance is where you take an action, you lie, and that causes harm to somebody. Nonfeasance is inaction, so basically a lie by omission. And the court really analyzed and struggled with this issue of, well, Davis had the right to inspect under the contract, but Johnson told Davis that the roof was watertight. Johnson told Davis that the roof was okay. So was it the inaction of Davis to get the inspection, or was it the misfeasance, the action, the lie of Johnson to tell Davis, no, the roof is watertight, everything is okay? And I think ultimately where the court came down was that the fact that Johnson told Davis, no, the roof is watertight, it was just some previous repairs and everything was okay, I don't think the court liked that Johnson had committed some type of misrepresentation or even to the level of fraud. And so I think that's ultimately why the court ruled in favor of the buyer, in favor of Davis. Now, the court's actual holding is where the seller of a home knows of facts materially affecting the value of the property, which are not readily observable and are not known to the buyer, the seller is under a duty to disclose them to the buyer. Now, let me unwrap that a little bit. Where the seller of a home knows of facts. So the first thing you got to prove is that the seller knew that this condition existed. The house is sitting on a repaired sinkhole, and the seller knew that because the seller's the one that owned it when the sinkhole was repaired. Or there's a hole in the roof, and the seller knew that because the seller is the one that owned the house at the time the roof was repaired. And a lot of this stuff you can find by doing a simple permit search. I know that in some of the counties here in Tampa Bay, even on the property appraiser website, you can go and search and it'll show you what permits have been issued. Some other things that how can you prove the seller knew? I had a case where the seller had a previous buyer and the buyer canceled the contract with an explanation. Well, when the buyer says, I'm canceling the contract because, then it's probably obvious that the seller knew. Had another case that I believe we have settled where, again, a previous buyer backed out because of something and told the seller, this is why we're canceling the contract, and the seller did not disclose that to the new buyer when the house was relisted. In another case, it was an investor. So all you investors out there, as you make repairs to these properties, there are things that you may know about that you may have to disclose. And so in this other case that I'm thinking of, the seller did all these unpermitted repairs. And not only were the repairs unpermitted, but they were done improperly. Well, investor, you did it, so you knew. And so we can prove knowledge in those cases. But that's one of the really hard first steps, is you have to prove that the seller knew of the facts. Now, the second part, those facts that the seller knows have to materially affect the value of the property. So, again, I think of my own house. I got a honey-do list project here coming up where one of the screens is broken, and so I have to replace or repair the screen. And so let's say that we decide to list our house, and I don't tell anybody about the screen, and the buyer moves in, and suddenly there's this screen that they have to repair. Well, to repair a screen costs, whatever, $20, $30. You can get the supplies from a home improvement store and even do it yourself. And so the repair of a screen for $20, $30, $50, $100, the repair of a screen does not materially affect the value of the house. I'm not going to buy the house or refuse to buy the house over $100. So the repair has to be material. Like I've said before, sinkhole, roof, air conditioning unit, electrical unit, plumbing. It's got to be something material that the buyer says, I don't want the house if it's got that issue. I don't want to buy the house based on that issue. It's got to be material. It's got to materially affect the value of the property. So facts materially affecting the value of the property, which are not readily observable. So it has to be readily observable. Now go back to my example of the screen. Well, if the wind is blowing and the screen is blowing, it's readily observable. So, it's got to be an issue that you can see. It can't be hidden. So what might a hidden defect be? Again, a hole in the roof. There's a lot of places that I don't see on my roof. And so if I know there's a hole up there, it's got to be disclosed. The classic example that we learned in law school is someone takes a sledgehammer to the wall and then hangs a picture over it. Well, you put the picture over the hole to hide the hole. Now, repairing the drywall, I think, is a little bit different than covering up a hole with a picture. But it's got to be something that's readily observable. And this is really interesting because this brings in a lot of inspectors. And so a lot of times the call that I get is, my inspector missed it. Well, if you had a bad inspector, maybe it was still readily observable. Or you had a really good inspector, which means it was not readily observable. And if it's not readily observable, then it complies with the holding in Johnson v. Davis. Now, that brings up another point as well. A lot of people say to me, well, can I sue my inspector? From what I understand and what I've seen in the few inspection reports that I've read on these issues, at the end of most inspection reports here in Florida, there is a disclaimer paragraph at the bottom near where the home buyer signs that limits the liability of the home inspector to the cost of the inspection. And so if the inspection was $200, $300, I've heard them as much as $600, then that's something that the liability is limited to that $600 unless there's gross negligence. Now, gross negligence is such a high standard, you have to prove that the inspector was totally incompetent to get to gross negligence. So if it was something where the inspector just missed, they just missed it, it's probably not going to be gross negligence, and suing the inspector is not really going to get you anything more than the few $100 you paid to have the inspection. And suing the inspector is going to tip off the seller that, wait a minute, if they're suing the inspector, maybe I can say it was not readily observable because the inspector didn't find it. So you have to be careful of that not readily observable part of the court's holding. So facts materially affecting the value of the property which are not readily observable and are not known to the buyer. So again, if it's something that the buyer sees, it's known to the buyer. If it's not easily seen by the buyer, then maybe it may not be known by the buyer. So if you meet all of those elements, the seller is under a duty to disclose those issues to the buyer. Now, let me give you a practical, real-world example of a time when this did not apply. I was talking to a buyer once, And the buyer said, I want to sue the seller for failing to disclose a fire in the air conditioning unit. I said, oh my gosh, the air conditioning unit caught on fire? Yes. How do you know, Mrs. Buyer, that the air conditioning unit caught on fire? The buyer's response was, well, when I opened the air conditioning unit to service it, I saw all the char marks inside the air conditioning unit, inside the fan out in the back. Inside that unit, I saw all the charred remnants of the old air conditioning unit. And I said, oh my gosh, well, what kind of damages were you facing? What did it cost you to fix the air conditioning unit? And the buyer said, oh, it didn't cost anything. The air conditioning unit works perfectly. All of the parts, all of the guts of the air conditioning unit had been replaced prior to the buyer buying the house. The only thing that had not been replaced is the housing that then showed the after effects of this fire. So the air conditioning unit worked perfectly. It did catch on fire at some point in the past and was never disclosed to the seller. So let's run that through our definition here. The seller knows of facts. So here the seller did, because the seller replaced the air conditioning unit after the fire. Knows of facts materially affecting the value of the property. I think that's where this particular fact scenario falls down, materially affecting the value of the property. It wasn't the current parts that had caught on fire, it was previous parts, and those previous parts were replaced. The fact that the housing showed evidence of the fire didn't impact the reliability of the housing. It wasn't as if the air conditioning unit was going to be destroyed by rain because the inside had been destroyed by fire. But let's keep reading. Materially affecting the value of the property, which are not readily observable. True. The inside that showed where the fire is not readily observable. And not known to the buyer. Again, true. The buyer had no way to know that the air conditioning unit had caught on fire. But where I think this falls down is it didn't materially affect the value of the property because the seller had repaired everything. The air conditioning unit worked. The only problem with the air conditioning unit was that the inside housing had shown evidence of a fire, but it still worked and it was still structurally sound. So I think in this case, this was not a case that we pursued, and so I think that it would be fine. Now, let me tell you about one that we did sue. It was one that I told you about earlier that I believe we've settled. And so in this particular case, the seller buys the property, and then after closing, the buyer learns that his insurance has been canceled. And when he investigates why his insurance has been canceled, he learns that the property has been reconstructed on an old sinkhole. And so that sinkhole was never disclosed. Well, here's one of the issues that I'll talk about later. The seller was a bank that had taken the property back in foreclosure. And so my first inkling to this client was, well, wait a minute. The bank took the property back in foreclosure. The bank would have no knowledge. We can't prove that the bank knew that these facts materially affected the value of the property. I mean, I think all the other elements there are true. It does materially affect the value of the property. No one really wants to buy a house on a sinkhole. It's not readily observable. There's nothing there that shows that there was a sinkhole that was repaired. And it was not known to the buyer. The buyer had no idea that there was a sinkhole there. Now, interestingly, the seller's attorney argued that the buyer should have known because a public record search would have turned up some of the repair documents from when the sinkhole was repaired. But still, I think constructive notice, we settled before we really ever got to that issue. So I don't know that would be an issue, but that's what the seller was going to argue. But still, how do we prove that the seller knew of these facts? Well, interesting story. Our seller was talking to his agent about the sinkhole. Another agent in that same office overheard the buyer, and his agent talking about the sinkhole. And so that other agent walked over and said, hey, you're talking about the house at 123 Main Street, wherever the house was. The agent and the buyer both said, yeah, that's the house we're talking about. The other agent that had walked over said, yeah, my clients had a contract to buy that house. When they discovered there was a sinkhole there, they backed out of the contract. And so now we have knowledge because the previous buyers, told the seller we're not going to buy this house because there's a sinkhole there. And that then, I think, triggered the obligation of the seller to disclose to the buyer, hey, there's a sinkhole here at the property. A lot of times what people will argue is, well, the neighbors knew. The neighbors came over and told me that the sellers blah, 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 and the neighbors start gossiping and whatever. I don't know that is really relevant to the analysis because actually it's hearsay. What the neighbors thought the buyers were doing based on the house, I think that's hearsay. But in this case, we've actually got a former buyer that could testify that said, I wasn't going to buy that house. Now, the interesting issue this brings up is, how did the previous buyer find out about the sinkhole, but the new buyer, our client, did not find out about the sinkhole? And that may be geared towards the seller's argument of constructive knowledge. But regardless, we got the case settled. We got our client some money. He can make the repairs to the house. He can make the repairs to the sinkhole. He can self-insure the house. Luckily, I think he's going to rent this house out so he's going to use it as an investment, I believe. I don't recall if he's going to live there or not, so don't quote me on that. I believe it's an investment. But either way, the case has been resolved. The client is happy. I think those are two examples, one where there really wasn't anything affecting the material value of the property, and then in the other case that there was. And so again, we've handled both sides of the equation here. Now, I did a previous podcast episode. If you go look up episode 194, which was Thanksgiving from last year, and I talked about whether the seller of property in Florida has to disclose, but it was really short. I didn't really go into as much detail as I'm going into in this episode. But if you want more information about this issue, episode 194, which is our Thanksgiving episode from 2019, does talk about this issue a little bit. But let me talk about some of the practical applications here. So one issue that we run into a lot is, how are we going to prove what the seller knew? How are we going to get in the seller's head and prove what the seller knew? Now, sometimes, if it's a person that's owned the property for 20 years, we can do that by circumstantial evidence. I mean, if you've owned this house for 20 years and there's a hole in the roof, you have to have known there's a hole in the roof. But you know, some of the other ways. I mean, if the seller is a flipper, if the seller bought the property just to flip it, just to even flip the contract, how are we going to prove that the seller knew what the heck was going on inside the house? I don't think we can know that. I don't think we can prove that. Again, that's where people will go to the neighbors, who I don't know are necessarily the most reliable source. But, you know, again, how do we prove what the seller knew? Again, we get into this issue of readily observable or easily found or unknown to the buyer. You know, how do we prove all of that stuff? And so proving the elements, I think, is the first hurdle, is the first step in maintaining one of these cases. The other issue there is, are the sellers collectible? So let's say we prove all the elements. It's obvious that the seller knew. Let's use the hole in the roof. It's obvious the seller knew there was a hole in the roof because there were, the water was dripping every time it would rain, and the sellers would just clean it up and blah, 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 blah. So we can prove that the sellers knew. It's an issue with the roof, so it materially affects the value of the property. The buyer never goes there on a rainy day, so the buyer would never, ever know. The hole is in the roof in a place where an inspector would never see it, so it's not something that would be readily observable. The seller knows about it because the seller has cleaned it up multiple times when it rains. So check the box, check the box, check the box. In all those cases, the seller has to disclose that roof leak to the buyer. And let's say that the seller doesn't. But let me put this fact in here. Let's assume that the seller is downsizing and using the equity from the sale of the house to buy a new house. So this is the seller's homestead residence. They sell the house. They buy a new house. Now, under Florida law, the equity that you have in your homestead is exempt from creditors, period. So let's say that our buyer sues the seller and wins and gets a judgment for $30,000 to repair the roof, to replace the roof. But the seller has taken all the money from the sale of the property and used that money to buy a smaller house, free and clear, to live there. Well, I'm sorry, Mr. Buyer. Even though you got a judgment That judgment will not attach to the seller's new homestead property. You're now relegated to trying to collect through a wage garnishment or some other kind of asset levy or asset replevin or whatever, asset repossession. You cannot go after the money because the money's now in the house. You can't go after the house because the house is homestead and therefore exempt. So even if we're able to prove liability, we also have to examine collectability. Now, again, in the one case I told you about where there was the sinkhole and the seller didn't disclose the sinkhole, well, the seller was a bank. And so I think the bank has deep pockets that we can go after the bank for money. But, if the seller is a little old lady or a little old man or a couple with kids that take the equity and move into a new house, you can't get the money that they got at closing because that's now in the new house. You can't get the new house because it's homestead. Now, if the sellers use the money and buy an investment property, that investment property is fair game for a lien and a foreclosure. If the sellers are in business of doing this and they have tens of thousands, hundreds of thousands of revenue, their revenue is subject to collection. But if this is just an individual that lived in a house for a while and is selling it and didn't disclose, I don't know that there's much that the buyers can do to collect even if they get their judgment. And for that reason, we don't take a lot of these cases. They are really, really hard to monetize. And what ends up happening is the buyers get frustrated at us because we have to charge them fees to represent them in this case, and then we don't collect what they think they're entitled to collect, and they get mad at us and they say we do a bad job. So rather than doing all of that, I would just rather decline these kinds of cases. Now, a couple of things. First, I am not, by this podcast, telling you how to defraud your buyers. If you know that there's an issue with your house, you need to disclose it. That is the law, and that is what I'm advising you to do. If you call me and say, hey, Sean, here's the issue, do we have to disclose it? And it meets the qualifications of the Johnson v. Davis test, then I'm going to tell you, yes, you have to disclose it. I am not intending this podcast as a way for you to get around disclosing. I'm not giving you this podcast as a way to defraud people. And the second part of the analysis is I want these kinds of cases. So if you're a seller and you get approached by a buyer who wants some money out of you because they say you didn't disclose something, give me a call. Let's talk about it. Let's see if I can help you out of that situation. And the reverse is true. If you're a buyer and you move into your house and something goes sideways and you don't think that your seller properly disclosed it, give me a call. Let's talk about it. Let's see if it's something that we can help you recover some money. So I don't mean by this podcast to tell you how to get around the law, and I certainly don't mean by this podcast to tell you that I don't want these kinds of cases. I can absolutely, definitely help you, whether you're a home buyer, a home seller, an investor, a wholesaler, a flipper, whatever your profession happens to be. Yes, I can help you with this transaction. Now, if you're in the wrong, I'm going to shoot for settlement right away from the very beginning, right off the bat. If you're in the right, let's talk about it and let's see if we can saddle up and fight. So we are seeing an uptick in these types of cases, which is why I wanted to talk about it on both sides. I've represented now many, many sellers and buyers who are complaining about the other, that one didn't disclose, or I didn't have to disclose, or I did disclose, or whatever the situation. But again, the law in Florida, Johnson v. Davis, says where the seller of a home knows of facts materially affecting the value of the property, which are not readily observable and are not known to the buyer, the seller is under a duty to disclose them to the buyer. So that's the status of the case law in Florida. If you have questions, please reach out to me. Let's go over it. I also want to let you know we only have a few weeks left in 2021, and I do want you to be debt-free, hopefully by the end of the year. If not, we'll work on making you debt-free in 2021. Step number 1 to becoming debt-free is to check out my second book, Become Debt-Free in Less Than 1 Hour. You can find that SeanMYesner.com/become debt-free. So again, SeanMYesner.com/become debt-free. Thanks again for your time. Thanks again for your listening. We are very, very quickly approaching 100,000 downloads. In fact, we may even be beyond 100,000 downloads when this episode is published. So definitely connect with us on social media for those types of announcements. Thank you again for your time. Thank you again for your listening. Like I say at the end of every episode, at the end of the month, we hope you have more money rather than at the end of the money having more month. That'll do it for this week's episode of the Crushing Debt Podcast, and we look forward to talking to you in next week's episode.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.